I'm sorry that we are on Facebook/Zoom. I wish we were together. I think things are a whole lot easier that way, and the conversation will be a little bit easier, but we'll just do the best we can with what we've got here. My name is Roger Huber. I am the town attorney often. And I will be with you. I know you all know that there's been a couple of appeals that have been filed. I will be representing all of you. I'll be representing the board at that hearing next week. So we'll see each other again next week. And I look forward to working with all of you. So one fun fact about me is that many years ago, I sat where you sat. We didn't have Zoom, we didn't have social media, but I was a member of the Board of Appeals, and at one point, for a brief stint, I was the chair of the Orono Board of Appeals. So I know what it feels like to sit in your to be in your shoes. Have you all met before ever? No. Okay, well, then this is a timely meeting. I think we're here together tonight because of the appeals that were filed, and my goal is to just give you the basics of the process, of your jurisdiction, of your authority, give you some idea of what an appeal hearing will look like and what your obligations are with respect to the appeal. We will not be talking about the pending appeals. And in fact, I have consciously not provided you with copies of those appeals so that we didn't talk about those. I also didn't want the parties to think that we were talking outside of school about their pending appeals. So those will be sent to you. I'm expecting to send those out to you on Friday. We'll talk a little bit more about that at the end of this meeting. But this is what happens next week is sort of off limits for tonight. And in fact, one of your members, Bill DeVoe, who is a very experienced Board of Appeals member from Hamden, now in Orono, I actually asked him not to attend tonight because his firm represents one of the parties on the appeal next week, and I just did not want there to be any appearance that he had any in with the board. So I asked him not to attend, and he agreed to do so. So the purpose tonight is to really just focus on the basics regarding your authority. And again, it would be much easier if we were all together face to face. But really the goal for tonight is just to get you up and ready for next week. My hope is that once this pandemic is over and we can get together in larger groups, that we'll actually sit down and have a more thorough discussion and more thorough presentation. And I'm sure Sophie will accommodate that for us. Every appeal that comes before you will be different. And 99% of them will fall into one of two categories. We'll talk about those. But within those two categories, those two types of appeals, there's endless variety. So we won't really be talking about all the types of appeals that could be coming before you, circumstances. It just doesn't make sense to be that specific. My hope, again, is to be at about 10,000 feet, give you a sense for the board and your charge. So, can you hear?
No, I can't hear you. I'm listening to you on the phone. I can't actually hear you on my iPad. I'm pretty sure.
I hate to ask, but is volume up?
What's that?
Is the volume up on your iPad?
It is. Yep. Huh. Maybe it's because I'm on the phone. I don't know. So does anybody else have a clue how to, let's see, share content, participants. I've got you all, well, who's ever there. I've got mute. Wait a minute. Can you hear me?
Yes.
Yes. Are you hearing me in my phone? Or the icons just keep disappearing. Oh, there you are. And so there's the school, there's Gary, there's Jennifer, waiting for Paul Smith. And so I guess I'll just hang on to my phone and watch. Can you hear me?
We can hear you, but I can't tell whether it's through your phone or not.
Yeah, it must be through my phone, huh?
Yeah.
I mean, I can, in order
sound great.
to, I sound great? Okay,
You
well,
sound
we'll
great.
stick with it then.
But the thought of having you have to
Okay.
hang on the phone for that one.
I know. Oh, jeepers.
By hitting, so right by your microphone, there's a little arrow that points up. You can click on that and check to see if your microphone works there. But you're saying you're having trouble hearing, right?
No, I can hear you guys,
Oh,
but
okay.
it's coming through my phone.
Oh,
And
see.
I don't have a microphone icon.
Huh.
I mean,
Okay.
I'm on an iPad and there's a phone. I don't know. Record? No, I don't think it would be record. So I guess I'll just sort of hang in there like this, and I've got my charging cord ready if I need it.
Well, like I said, this is not the ideal presentation
Yep.
mode, and it'd be great if we were all together, and we certainly will be next week. So actually, we'll be this
Testing.
way next week.
Testing.
At some point, we'll
1,
be
2,
face to
3,
face.
testing. This is Shane. Question
Shane.
for you. Is there any possibility of town provided technology being available? In other words, set us all up in separate little rooms on town property? Because I could see these technical bugs on our half being a grounds for appeal if too many of us have technical issues, the appellant could say, oh, you didn't have a valid meeting. Is that possible?
Well, the courts have the governor has been very generous about giving the towns, the municipalities wide berth to work through this electronic process during this pandemic. Yeah, if we have to be able to, the board has to be able to hear the appellants, and the appellants have to be able to hear us, and those the parties and the witnesses, we all have to be able to hear each other. And if that doesn't happen, well, then we'll just have to find another route. We'll just have to find another route.
So
what
is
I
there
meant
any
by that
chance
was-
we can be in a room where we're 6 feet apart?
Exactly.
I think it's the 10-person rule.
Oh, okay.
I think it's the
Okay.
10-person rule. I think there's probably room for all of us, but you've got 7 members of your board. There are at least 3 people involved in appeals. They're all going to have their clients and their witnesses.
It couldn't be the 50-person rule at church if we had a big enough space. You know, a large room at the high school or something, or Ace Adams.
So I would just say that we can provide some technology. Council has been using this technology fine for council meetings. And the concern is that once we spread out people and try to broadcast it, because it's still the hearing is still a public meeting, the quality of that meeting is severely degraded, and people can't understand what people are saying and can't see faces. So I think the thought here is, if we have some folks who don't have the technology to be on camera and fully participating, that I can absolutely provide a laptop to folks, and even hotspots if you need internet connection.
Okay, so let's start from the very beginning. The Board of Appeals is a creature of the town's charter. And it is the town charter that defines exactly what your power, what your authority, what your jurisdiction is. And the charter says that you all have the powers and the duties prescribed by the laws of the state of Maine. And that's reflect to and allows you to entertain appeals flowing from the town's land use ordinances, including shoreland zoning. Your charter, the town's charter, also gives you the authority to hear appeals based on the town's housing code, the building code, and any other regulatory ordinance that the town has or will adopt in the future. So you're primarily a land use appeals board. There are some towns where the Board of Appeals entertains tax abatements and assessment challenges, but Orono has a Board of Assessment Review that takes that charge. There are also towns that have where the Board of Appeals serves as the Personnel Board of Appeals, but the town of Orono also has an appeals board. So your board is focused almost exclusively on land use and permitting issues. Now, there are two types of appeals that will come before you. 99% of the appeals that come before you will fall into one of two categories. There's the administrative appeal and the variance appeal. I want to talk about each of these because they're a little bit different. We don't need to talk specifics, but these are two different types of appeals. Everything you do will be in one of these two categories. So the administrative appeal, and just not to ruin the excitement, but what is coming before you next week is an administrative appeal. But the administrative appeals are the appeals where somebody is challenging a permit that has been issued by the code officer, or a denial of a permit issued by the code officer. And in those appeals, the parties are saying, you know, that the code officer committed an error, or he failed to do something, or what he did was wrong, or that his interpretation of the ordinance was wrong when he issued or refused to issue or denied a permit. Again, this is the type of appeal I might file for a building permit and get denied for some reason. Perhaps I don't meet the setbacks. I think I did. Code officer says I didn't meet the setback. I'm going to appeal that issue to the Board of Appeals. What's important about administrative appeals is that your review of the code officer, you're not really reviewing the code officer's decision. you are looking at the issue de novo or afresh. You are taking all the evidence that is presented by the code officer and the aggrieved party. You are looking at that evidence brand new and making your own decision. Okay, you're not reviewing really what the code officer did. You're looking at it brand new and making your own decision. Does that make sense?
Yeah.
So that means that you're, at the hearing, the aggrieved party, let's say, for example, that the aggrieved party was denied a permit for whatever reason. You are going to, that aggrieved party can present evidence. He can present evidence that he never even gave to the code enforcement officer, and try to convince you that he was entitled to a building permit. The code officer will also attend and will explain why he or she denied the permit. But you can take new evidence. You can take new, you can take testimony from anybody that has something to say that is of value and is relevant. And in fact, it is your obligation as the Board of Appeals in an administrative appeal to create a record. Because if this matter, and we'll talk about this in a little bit, if your decision gets appealed to Superior Court, the Superior Court is going to be looking to see whether you made the right decision, not whether the code officer made the right decision. So it's super important that we go through the steps during the hearing and in the steps leading up to the hearing, that we build the proper record so that whatever your decision is, it will withstand attack on appeal. I would contrast that, I'll contrast it now with appellate work, where again, you're not really looking to see whether the code officer, I mean, the question is whether the code officer did the right thing, but you're not reviewing his decision. You're making this decision all afresh. You're making the decision on your own. There are certain decisions of the code officer which are not appealable to you, that you might think are appealable as an administrative appeal, but are not. And that is an enforcement decision that is made by the code officer. So if the code officer comes to my house and says, Roger, you have built your house or your deck 10 feet over the line, and I'm going to bring an enforcement action against you. I'm going to take you to court and I'm going to make you tear that down. I can't take that enforcement decision and appeal it to you. I have to go through that court system. The Orono Charter specifically says that enforcement decisions are not appealable to the Board of Appeals. Oftentimes people want to do it. And in fact, there are towns where enforcement decisions are appealable to the Board of Appeals, but Orono says no. And in fact, Orono is very smart to say no, because appealing enforcement decisions creates all sorts of problems, and so Orono's in the right camp on that front. The other type of appeal is the variance appeal. And we've probably all heard about variances. Variances are when I want to do something, when a landowner wants to do something with their land, but to do so would violate a provision of the land use ordinance. So the landowner comes to the board and says, look, I know I don't meet the setback, but for these reasons, I would like a variance from the setback requirements as it pertains to my property. You are the only board that can grant a variance. Code officers can't grant them. The code enforcement officer can't grant them. The planning board can't grant them. The town manager can't grant them. The Board of the Appeals is the only entity in a municipality that can grant a variance. Orono is, what's that?
In all municipalities or just Orono?
In all municipalities. In all municipalities, okay. That is one of I said you are a creature of charter, you are, but there are also a few state laws that apply to your activities. And one of those, your charter says you can't, or that you're the only entity. State law also says that. So your charter obviously is consistent with state law. Orono's a little bit different. In most cases, well, I'll just tell you what Orono does. Orono allows parties to get variances from height requirements, setback requirements, area requirements, frontage requirements. Okay? Height, setback, area, and frontage requirements. But in order to get a variance from those requirements, any of those requirements, the applicant has to demonstrate that application of the standards that they want a variance for create an undue hardship on them. And the term undue hardship is defined, and I'll just give you a quick rundown of what those is. So in order to get a variance, for example, from the height requirement or a setback requirement, the applicant that comes before you has to demonstrate to your satisfaction that the land in question their land cannot yield a reasonable return unless they get the variance. It's a pretty high standard, especially if it's for something like a deck. My property will still probably yield a reasonable return even if I don't have a deck. It's a high standard. It's intended to be a high standard. And I will tell you that the Maine Supreme Court has sort of defined reasonable return as it's a very high bar. If you can make any use of your property, the court has said that's probably a reasonable return. So it's very difficult for someone to meet that particular prong of the undue hardship test. So that's one. Two, that the need for a variance is due to the unique circumstances of their individual property and not the area or the neighborhood at large. So I have to demonstrate that it's because my property is unique. For example, the size of my property is so unique. It's not like all the other properties around me. It's unique because of this size or this shape that I need this variance. And the reason that standard is in place is because if the need for a variance is common amongst a lot of people, all your neighbors, then the town should deal with the issue through zoning, not through sort of piecemeal looking at each individual parcel. So the applicant is going to have to demonstrate that they're a little bit unique compared to their neighbors. The third of the four prongs is that the granting of the variance will not alter the essential character of the property. Of the four, that's usually the easiest one it's usually the easiest one to satisfy. You know, if I've got property on the lake and I want to add a deck, probably everybody else has a deck. You know, adding a deck or expanding my deck isn't necessarily going to alter the essential character of the neighborhood. And the the fourth standard is that the hardship necessitating the need for the variance is not the result of action taken by the applicant or the prior owner. So if I owned a large piece of property and I sold half of it, and as a result, I need a variance now to build a deck on my remaining land, I'd have a hard time satisfying that criteria because I created the need for that variance. I did it by selling off more land than I should have. Variances are so hard to come by. And in fact, in 30 years of practice, I have never seen anybody that's actually legally required or legally entitled to a variance. That being said, they do get granted. And I should probably not say this because we are live and this is being recorded. But when I first joined the Orono Board of Appeals, my partner said just what I said. He said, you'll never see somebody that's entitled to a variance, but some point in your career, someone will come before you that you'll think, oh, this is where a variance should be granted. They may not meet strict application of the undue hardship test, but it'll happen. And sure enough, when I was on the board, we granted a variance to the Orono VC Water District. And I think it was for the plant down on the water. I don't feel bad about it. It probably didn't meet the technical requirements, but it was close. So in order to get a variance from height, setback, area, frontage, the applicant needs to be able to demonstrate to you that not having that variance creates an undue hardship, and the undue hardship test are those 4 prongs. They have to be able to demonstrate to you that they meet all 4 of those prongs before they are entitled to a variance. Orono is a little bit different in that it goes a little bit further, is a little bit more generous to its citizens. And it says that for variants that are related to dimensional standards, like lot coverage, some setback requirements, that you need only demonstrate something called a practical difficulty. Practical difficulty is something easier to satisfy than an undue hardship. We don't need to go through the test. Just know that there is a test, just like there is for the other types of variants. But it's a little bit more relaxed than the undue hardship test is. How this would happen at a hearing is you would get an application for a variance. And at the hearing, you would determine in what category the variance request falls. You would determine which test is going to apply, and then you would elicit from the applicant evidence to support that particular test, whether it's the undue hardship test or the practical difficulty test. One more type of variance. There's a thing called a disability variance that is exactly what it sounds like. It is to allow people that have a disability to make changes that may be inconsistent with the land use ordinance. The standards are even more relaxed, but they have to demonstrate a number of things. In most boards, and I've dealt with Orono on this one before, most boards will say, yes, we'll grant you that variance. I should say the best example is a ramp onto the property. that may be too close to a property line. Somebody has a wheelchair, can't get into their property, needs to build a little bit closer to the line in order to facilitate the construction of a ramp. The board has the ability to grant that variance without applying the undue hardship test or even the practical difficulty test. But the board also has the ability to limit that variance to a term to include just the amount of, when that person for so long as that person has a disability, or for so long as that person with a disability resides on the premises. The other types of variances run with the land, they'll go to subsequent landowners, but the disability variances are usually conditioned so as to just accommodate the individual or the family or the person with the disability. And once the need for the variance has disappeared, so too does that variance. Have I lost anybody yet?
Nope.
Because I can keep trying. I'll keep trying. So again, and I really don't want to get bogged down in details, but again, you're going to get one of two appeals. Most of them are going to be administrative appeals, but you might get a variance appeal. It's just going to be one of those two types of appeals. Frankly, actually, I was going to say this board may never get an appeal, and obviously you haven't until now. But those are the two big types of appeals. And I will say the town of Orono is very good at supplying guidance to its boards. You will likely always have somebody, an attorney with experience, sort of walking you through the steps. And that's why I'm kind of focused on the 10,000 feet, just to give you all a framework, as opposed to focus on very specific details, which you would never remember anyway. Okay, so you're authorized to hear the appeals. There's two types of appeals. Let's talk a little bit about the hearings. Whether it's an administrative appeal or a variance appeal, you have to hold a public hearing on those applications. The hearings have to be publicly noticed. They have to be held in public. You all don't have to worry about that. Sophie and her staff are very good about taking care of all that. Excuse me. All you need to do is show up at the hearing, but know that behind the scenes, that the public has been made aware of this hearing and has been invited to attend. All of the hearings are recorded, either video or video and audio. The public has a right to attend. The parties have a right to attend and to participate by presenting evidence and arguments and asking questions of each other, cross-examining each other. I mean, that's a right that each of the parties to the appeal have. The parties to the appeal in an administrative appeal could be just the applicant for the permit and the code enforcement officer. Sometimes administrative appeals can involve multiple parties, and so you may get multiple parties with multiple witnesses. You just don't know. But typically you'll have somebody on both sides of the equation, and they are entitled to make their pitch and to present evidence, to make argument, and to cross-examine each other. I don't know that you have elected a chair. I can tell you that Bill DeVoe is, who I know is on this board, but is not here tonight at my request, is a very experienced chairperson, and it really is the chairperson who runs the meeting. There's no guidelines in terms of how long a party can speak, what type of evidence they can present. The rules of evidence do not apply. It's really a question of relevancy. If a party brings up relevant evidence, you should entertain it. You don't necessarily have to give a lot of weight to it. That's up to you how much weight you give to each, but every party is entitled to present the evidence, and as long as it's relevant and not duplicative, the board and the chair should probably accept that evidence into the record.
How will the evidence be physically presented, and how will we receive it?
Good question.
Because that's a concern I've got, because a lot of times in these meetings, you know, they have these grainy pictures. They'll hand out copies and we'll pass it down the line of seats, and everybody will look at whatever wacky 20 pictures they send us. So how are you going to do that in a virtual meeting?
Yeah, I've never thought that was the arrangements that we have made. And when I represent a board, I always set a hearing date, and then I let the parties know that if they will provide evidence that they intend to present, if they will get that to me in advance of the hearing, that I will distribute that to the board members in advance so that you all have an opportunity to review it, to digest it, to consider it, and you know, parties are foolish not to take advantage of that. To think that they're going to show up and hand you a stack of evidence on the night of the hearing, and to think that they are going to you're going to be able to digest it and make full use of it is kind of silly on the appellant's part. So I always give them an opportunity to present written argument evidence in advance. I encourage it. I told you we weren't going to talk about this week, or next week, but I will tell you that I intend to send you the appeal documents on Friday via email. Not ideal, but in this era of COVID-19, we work with what we've got. So I will send you the appeal information on Friday via email. And then I have set Monday as the deadline if the parties want to submit evidence in advance to get that to me, and I will distribute that to all of you. I've also told them that if they want to do it later, they can submit it at any point, or they can bring it to the meeting. I mean, they could submit it after Monday, or just bring it with them to the meeting, but they sort of do that at their own risk. I said I will do my best to get the stuff to the board if they get it to me past Monday. But it's a little, at some point it becomes unrealistic to expect that you're going to paw through all their information on the eve of the hearing. So my hunch is that the parties will get that information to me, and I will be able to get it out to you. But Shane, you're exactly right. I mean, sometimes these hearings become a mess, and it's not really the board side. It's not the board's problem. It's, you know, sometimes these people just show up and they bring one picture, and you're right that you have to share it on down the line and bring it up, and it just loses its effectiveness as an advocate. So, but that's their call. It's their hearing. I mean, it's their hearing. They get to decide how they want to present their evidence to you, but you know, they sort of do so at their risk.
So evidence is only for the board, not for the public. Is that correct?
That is everything that goes to the board. We're going to talk about this a little bit under the Freedom of Information Act. Everything that is presented to you is a public document. So it is, it is your hearing. You know, if there are 6 members sitting on the board, I will ask them to bring 7 packets, 6 packets. The public won't be given a packet unless there's an extra one. But those are public documents. And the public is entitled to see those, maybe not necessarily at the hearing, unless it's not disruptive. But those are public documents. Everything you do is public,
Okay.
including the evidence that you receive. And in fact, I'll tell you, at the end of the day, when the hearing's all over, we will bundle up all the evidence, the video, the recording, any evidence that was presented, and the written decision. We'll bundle it up into a packet and put a rubber band around it and stick it in the clerk's office. And any member of the public that wants to come and see that at some point, welcome to come and see it.
So I take it, because this is public, that we are not going to deliberate in private. It's all going to be deliberations right there at the time.
You guys are skipping right to the meat of it. Yes, you are. You will be deliberating in public. There are a few times when you can go into executive session where you exclude the public and you just talk amongst yourself, but not for purposes of deliberation. Sometimes boards will meet with their attorneys in advance to talk about the rights and the responsibilities of the board. That's lawful under the Freedom of Information Act. But deliberations, not at all. All public. All public.
Right. So I take it that we're going to discuss 2 cases on the 20th?
Didn't I tell you we weren't going to talk? No. Yes. I think I can tell you that there are 2 building permits and there are 2 parties. So each party filed an appeal of each building permit. So one party has 2 appeals and the other party has 2 appeals. And without getting too much into it, I will recommend to the board that those be consolidated, and the parties have agreed that those should be consolidated so that it's the same evidence, it's the same everything else. So the parties have acknowledged that just makes good, efficient sense.
So these appeals are related. Maybe I shouldn't be asking this stuff because you're going to get to it.
You should not be asking. Yes, they are. They all involve the same. Yes, they are. They are very similar.
They're related.
They
Got
are
it.
very similar.
Okay.
I can't even wink to you in this setting. Yes, they
I
are.
know it.
The property is the same, and the parties are all the same.
Okay.
I can.
And are they? I'll just shut up.
So no rules of evidence, and in terms of the quality of the evidence, you're just the board and this chair should just be looking to make certain that it's the type of information that a reasonable person would rely on in making decisions. You have to go through a hearing to see how smooth it goes, but rarely are there questions of evidence. It's almost easier to take everything in and then just assign limited weight to it. Just like a courts often do. They'll just take it in, but they won't give much credence to the evidence. the parties are entitled to be represented by counsel. Sometimes they are, sometimes they aren't. Sometimes it's better to have them represented by counsel because things go a little bit more smoothly, but not always. So you can expect that that parties may have attorneys with them. You should know that you are never under pressure to make a decision that evening. Rarely do you have to go multiple nights, but sometimes sometimes the hearing topic is and the number of witnesses is so great that it just makes sense to hold hearings over a period of days. You also may get to a point where you have a question, a legal question that the attorney doesn't know the answer to and may say, hey, let's adjourn this meeting for the evening and we'll come back, we'll continue the meeting to another date so that you can get some solid legal advice. That happens occasionally. But you always have that option. You always have the option to continue the hearing till a later date. There will be an agenda. I will walk you through on Thursday night for sure, but any night we will walk you through the sort of the preliminary matters, the roll call, make certain that you have a quorum, which I think Orono says is 4 regular members in attendance. If you don't have 4 regular members in attendance, then the board can't conduct business, and the meeting has to be postponed till another date. It's not even continued. It doesn't even get open because there's not enough of you to call a meeting to order. So at least 4 of you have to be in attendance. One issue that often comes up on the quorum front is if I'm representing a party, I want as many people there, members of the board, to be there as possible, because that means I don't have to convince everybody. It means I can convince, all I need to do is convince a majority, and it's maybe easier to convince a majority of 7 than it is to convince a majority of 4. And sometimes if it gets too close and it's a controversial matter, sometimes boards will say, hey, listen, we've only got 4 members. Would you like us to wait until we can pull together 7 members or 6 members? That's an option that the board, the chair, can offer to an appellant. It's just an option, and the board does not have to extend that offer, nor does the party have to take it if it is extended. As long as the board has 4 members present, it can go forward. It can go forward with the hearing.
Okay, a question on
So
quorum
there's-
and numbers and stuff. And I'm just trying to remember how this goes. Okay, so let's say we have 4 out of 7. Now, are there some issues that could be decided 3-1, but other issues you must have 4? I thought there was one side of the coin where we had to have 4 people voting affirmative.
Does a variance require 4 in the affirmative in Orono? I don't know, Shane.
That may be the one. That may be the side. I just knew there was one side of it where we had to have 4.
Yeah, it may be a variance, and it may be a variance in the shoreland zoning context.
Okay.
And Sophie just popped on. She knows the answer.
Well, I hate to dispute the town attorney, but I've been trained that it requires a majority of the number of the board. So if we had 4 people present, we would need a vote of 4.
Okay, okay.
I'm not a lawyer.
And Sophie already knows this. I represent so many towns. Every town's ordinance is a little bit different. That would not surprise me. Okay.
Roger?
Yes.
I know that in the past on the board, we've had associate members that could fill in if one of the regular members was not there. Do we not have associates anymore, or can they not fill in?
No, you have alternates. I don't know that you have any alternates. You have such a thing. Do you have alternates appointed?
So we have an alternate that was appointed, but the alternate was appointed after this appeal was filed. So we would keep things clean. We don't want it to look like the council's stacking the board one way or the other. So we would not seat somebody until after all appeals have been heard.
Okay, I was just curious.
Dennis Cross, by the way, is the alternate.
Okay.
Oh, good. Good. Paula, did you have a question?
Actually, Shane asked it.
Oh, good. Good.
Yeah, I was.
So at the hearing, the chairperson sort of directs the meeting. The appellant goes first, typically without interruption, and then the other parties follow. When the appellant is done, the board can always ask questions. It's always kind of nice to give the appellant an uninterrupted opportunity to make their pitch. But the board technically can always ask questions. And when the appellant is done, then the other parties should be given an opportunity to cross-examine that appellant, should they so desire. And then if there are multiple appellants, they should all speak they should all speak sort of before the appellees. And again, the ability to cross-examine is a super important right that people have. And you'll get a feel for it. A good chairman, a good chairperson will keep control of the meeting, but typically there's banter that goes back and forth, and you may cross and then the other party gets a chance to speak. It's kind of nice to just let everybody have their say, if that's possible, before the hearing is closed. Sometimes it's not. Sometimes it gets a little chaotic. Sometimes it gets a little adversarial. Sometimes there are people that just want to say the same thing over and over again, but in a slightly different way. The chair and the board have total control over that presentation, but don't panic. Most of these hearings are usually very sparsely attended. It's usually just the people that are interested, and most often it makes sense to just allow people to say their piece in an orderly fashion, always getting a chance to cross-examine the person that just went before them. There are a couple of basic issues that need to be addressed at every hearing, and these will go, the board will simply have to make a finding on both of these issues. One of them is jurisdiction. The board will have to make a finding that in fact it has jurisdiction to entertain this appeal. The type of appeal, go to the charter, go to the ordinances of the town, make certain that you have the right or the jurisdiction, the authority, the power to entertain the appeal. And a specific finding should be made on that front. Also, there are filing deadlines, there are timing deadlines that must be met in order for this board to have jurisdiction. It may be, I'm guessing it's 30 days. I should know off the top of my head. If a code officer makes a decision, you're not happy with it, I think you have 30 days to appeal that to the Board of Appeals. If you wait until 31 days, you have lost your right to appeal, and the board does not have jurisdiction to entertain your appeal. So the board should always make a finding in terms of what decision is being appealed from, when was the appeal filed, was it filed in a timely manner? The other question is standing. Standing is simply a legal construct that requires that you have some basic right to be before the tribunal. So I file a bill, I get denied a building permit. My next door neighbor, and I'm denied, somebody 2 blocks, or maybe I'm granted, somebody on the other side of town doesn't have standing to appeal that decision. Somebody next door to me has standing to appeal that decision because they are aggrieved in a sort of a unique way. But somebody on the other side of town probably does not have standing to appeal a building permit that was issued to me. So it's important to make a finding as to why or how the parties have standing before you. Again, as we talked about at the beginning, we'll talk about at the end, it's important that you put together the record and that your written findings are supported. Any court is going to review this, is going to look at your jurisdiction, make sure that's good, and make sure that the parties that are involved and participated had standing to do so.
What if there's a conflict of interest?
We're going to get to that.
Okay.
Going to get to that. And
all right, I'll mute.
I'll just save it for the end because that it happens, and in fact, it's going to happen on this appeal. But we'll get there. Site visits. I don't think when I was on the board, I've ever went on a site visit. I don't think in my 30 years of practice, I've ever been with a Board of Appeals that conducted a site visit, but it's always an option. It's a little bit more problematic in this COVID era because site visits are public and the public has a right to participate and to attend. But obviously there are restrictions in the number of people that can gather. So if that's of interest at any time, that's an option that the board has. You also can drive by the property. I mean, you can't be prevented from driving by the property by yourself. Once you know where the property is. The problem is, though, that whatever you glean really isn't part of the record. It really isn't. It isn't part of the record and shouldn't be relied upon when you render your decision, because your decision should only be based on the evidence that's presented to you. So sometimes it makes sense to drive by, just be able to put it in context. It's certainly a little bit easier to understand the map that's being displayed when you've actually seen the property. But never go out with anybody else. Don't go out. You're not entitled to go out onto the property. You don't have that right. But I won't say that you can't do a drive-by and look at it. I'm kind of lukewarm on the whole idea. But if 2 or more of you are going to get together and do it, it needs to be a 3 or more. It needs to be a noticed hearing, and I completely would discourage you from doing that. So both parties make their case. They've cross-examined each other as much as they want. You've asked them whatever questions you have of them. The chairperson closes the hearing. At that point,
When you're saying parties make their case, now is it clear that one party will be our code enforcement officer and the other party or parties are various people in the general public?
yes.
Okay.
You will have an appellant and an appellee. You will have, yes. And the code officer the code officer will always, it wouldn't be in a party necessarily in a variance appeal, but in an administrative appeal, code officer is always the party. So the code officer will always be in attendance, and the code officer will be in attendance for a variance appeal also, but I don't think technically that the code officer is a party to the to a variance appeal. You close the hearing, deliberations begin. Oftentimes deliberations begin with a motion to either grant or deny the appeal, and then that motion goes under discussion, and you all weigh in with your thoughts, your concerns, your viewpoint. You can continue to ask parties, witnesses, questions if you need to after the public hearing is closed. They don't have a right to speak unless you give it to them, but you can continue to ask questions if something comes up during deliberations, for sure. And then we'll know by Thursday night exactly how many people are required to pass a motion. But it is the deliberations are super important, and it's important for you all to educate each other as to your respective positions, to help each other come to a good, solid, supportable decision. But for the person who is writing the decision, which in this case would probably be me, it's incredibly helpful and important that I know why the board did what it did, because that's what's going to serve as the basis for the decision. And if it's me, I will poll each of you. If it's another attorney, maybe they'll do it a different way. But my style is to poll each of you and ask why you voted the way that you did, so that I can put that, it can be of record, and so that I can put that in a written decision. Because as we'll talk about in a minute, the Superior Court is going to want to know why you did what you did, and the Superior Court's going to be looking at your decision, not the code enforcement officer's decision. So again, super important that your decision be documented and explained in sufficient detail. And the only way to, obviously not a mind reader, obviously the only way to do that is to poll each of you and get a sense for where you stand and why you voted the way that you did. Decision has to be in writing. It has to contain findings and conclusions of law. It has to contain supporting facts and rationale. And of course, it's got to contain the ultimate decision as to whether you're going to grant the appeal or deny the appeal. And I'll give you I'll tell you what my style is. There's a number of ways to do it, but typically at the end of a hearing, I will do as I said. I will poll. The board will make its decision. I will poll if I haven't gleaned from the deliberations why people are voting the way they are. I will poll you. We will then continue that. Once the vote is taken, we will continue the meeting to a date in the future that will allow me to put together a written decision. I will then email you each separately, not together, separately, a draft of that written decision so that you can make certain that it reflects what you feel the board did. And then we will come back and I will make any changes that you as individuals provide to me. Again, we're not deliberating, you're not together, you're separate, but we want to make sure the decision is right. And then we will come back together on the date that we set, and you will simply vote. You will have all seen the decision, you will have all signed off on it, you will vote to approve it. And that will end the appeal. Does that make sense? That make sense?
Yeah.
Some people will try to write the decision that night, and so while I know it's probably been a long night anyway, and then everybody's sitting around while somebody is writing as quickly as they can. In this day and age, in this day and age where people are as litigious as they are, and the courts are focused on, the courts would love nothing more than to send it back to you to get to further elaborate on what you did. It's just more efficient to just get it right the first time, get a good vote on it, have you come back for 5 minutes to open a meeting, vote on the written decision, and call it good. So it's I think it's time well spent. So that's tends to be the way I do it. Okay, so you've written it, you had the hearing, wrote a decision, we came back together, you approved the decision, it's delivered to all the parties. At that point, the parties have 10 days to request the board reconsider its decision. It doesn't happen very often, but it does happen on occasion. Somebody will say, nah, the board just got it wrong, or we think you missed something, or you misunderstood us, or whatever. They can file within 10 days of your issuing a decision, they can file a request for reconsideration. The board has to vote to reconsider it. And then if they vote in favor of, actually, the board's going to have to hold another meeting on it. The board has to then vote at its meeting, a new meeting, whether to reconsider or not. And if they vote to reconsider, then they hold a reconsideration hearing, which could look exactly like the first hearing. You're entitled to take more evidence. The parties are entitled to submit additional testimony. It happens. The restriction that the board has is that the board has to vote to reconsider and reconsider if the board has to vote to reconsider, and if it votes to reconsider, has to hold the reconsideration all within 45 days of the final meeting, or the date of the decision was issued. So the time frame's a little bit more compressed. It's not it's usually not that difficult to get together within the 45-day period, but it's a deadline that's important and needs to be tracked, and we would certainly do that on your behalf. Again, it doesn't happen very often. In 30 years, I think I've probably been involved with 2 reconsideration hearings, and both times the board voted not to reconsider. So they got together and said, yeah, we've looked at it. We think we got it right the first time. We don't think there's anything that you could tell us that is going to change our minds. We vote not to reconsider and to stand by our original decision. parties do not have to apply for reconsideration. They can simply appeal straight to Superior Court. They have, once you issue a decision, they have 45 days to appeal to Superior Court. And the difference now, remember, you sat in a de novo capacity. You built the record. You took new evidence, you testimony. You weren't reviewing what the CEO did. You took new evidence and you came up with your own decision. That's not what the Superior Court does. The Superior Court is going to take your decision and they are going to review what you did. And their question, what they're looking at is, one, did you commit an error of law when you, in issuing the decision that you did? Did you abuse your discretion somehow? Or are the facts that you found in support of your decision, are they supported by substantial evidence in the record? And if they are supported by substantial evidence in the record, your decision is going to stand. Substantial evidence in the record actually means any evidence in the record. So as long as there's some evidence to support what you found, ultimately found, then your decision is going to meet that prong. Again, a well-written decision explaining what you did, why you did it, is likely to be upheld. And things get overturned on occasion, but not all that often. The courts give a tremendous amount of deference to local boards, but they do get appealed, or they do get overturned on occasion. But again, a well-written, a well-thought-out decision is going to get you beyond Superior Court. You aren't involved with that. You've done your job. When you sign the decision, unless there's a reconsideration, you have done your job, and it is the party's decision as to whether to go to Superior Court, and it is the parties and sometimes the town that will defend the decisions, but your role ends at issuing a written decision. Still making sense? If a party is not happy with what the Superior Court does, they can appeal that decision to the Maine Supreme Court. It is an appeal of right, so the Supreme Court has to take the case, has to look at it, but the Supreme Court is going to do exactly what the Superior Court did. It again is looking at, it is an appellate court, and it is going to review the decision in an appellate capacity. It is going to look to see whether you abused your discretion, committed an error of law, or made findings that were not supported by substantial or frankly any evidence in the record. But again, at that point, you're just bystanders watching the process play out. In 15 minutes, I just want to run through some really quick things: bias and the freedom of access law. Let me take freedom of access law first. Maine has a freedom of access law and an open meetings law, and it entitles the public to attend your meetings. All of your meetings are open to the public. The public needs to be notified of them. When Sophie came on today, she made it clear that we were Facebook Live. That's because the public is entitled to attend not only your hearings, but your workshops. Everything you do is open to public inspection, all of your records. Jennifer asked if the evidence was public. It's all public. Everything you do is public. Notice of your hearings has to take place. If it's not noticed, you can't hold a hearing. Again, the town will take care of that for you. The appeals should not be discussed outside of the hearing. If you see your fellow board members at Woodman's, it's not an appropriate time to discuss the appeal, the substance, or frankly, anything about it. The public is entitled, the parties are entitled to be a part of your discussions, and obviously they are not there. You are discouraged from and should not have contact with the parties, either individually or outside of the hearing. Emails and discussions between board members, really bad idea. Again, what you do as a board and board members is public, and the public is entitled to it. And if you're conducting private discussions amongst yourself, either in person or via email, the public is obviously being excluded from that. And as I indicated, there are times, limited times, when this board can meet in executive session with their attorney to talk about the rights and the responsibilities that you have as a board, or even perhaps as individuals, concerning a pending appeal. But those times are really few and far between. The executive sessions are absolutely the exception, not the rule. You should expect that everything you do will be in public. Conflict of interest. It arises, the smaller the town, the more often it arises. We have, I think I'm not out of school to talk. We have one of your board members, Bill DeVoe, his firm represents one of the parties that will be appearing before you on Thursday. Obviously, that's a conflict of interest. He cannot sit on the board while his partner presents a case for an appeal to the board for its consideration. So Bill quickly recused himself. And as I said at the outset here, I actually asked him not to participate here because I didn't want the parties to think that there was anything untoward going on. He certainly could have. There was no anything legal preventing him from participating here tonight. I prefer to keep things clean and not create any issues that might be appealable. There are a couple of different types of conflicts of interest or bias. There is a statutory financial test for conflict of interest. I think you will probably be surprised. I'm always surprised every time I read it, that an officer or director of a business, you could entertain, I don't know how to say this, an officer or director doesn't have a conflict of interest if they own less than 10% in the entity. So if I had a business and I was coming, but I could rule on it. I could have that business could come before me as long as I owned less than 10% of a financial interest in that business. That doesn't seem right to me. That seems like even 1% would bother me and would bother most people. And so there's not only statutory conflicts of interest, but there are conflicts of interest cases that have come up through case law. And really the bottom line is that if a person is going to be put in a situation of temptation to serve their own personal interests, that person probably should not be sitting on that board. And oftentimes people will acknowledge it. They'll say, look, this doesn't feel right. I do business with this company, and if they get this, then I may benefit from it. Well, that's not really a conflict of interest, but it certainly looks like one. It feels like one. And it may appear that I'm being tempted to rule in a particular way to favor me. And so the board member should certainly make that known for the record. And either the board member says, I'm not going to participate, I recuse myself, or the board member can ask the board to make a ruling. I mean, if the board says, the guy says, if the board member says, I'm not going to get out, I can do it. The board can still hold a vote and vote that person as having a conflict of interest, and forcing that individual to step off the board for that particular appeal. There's bias based on blood or marital relations. It's never, you should not, if a family member comes before you, you should not be sitting on the board. If whether that's by blood or marriage, there is there's bias based on sort of a, I don't know, state of mind. You know, Roger, boy, for years I've heard Roger talk about how much he hates this person, and now this person is coming before him for an appeal. It may be that that person says, Roger, you know, I'd ask Mr. Huber to recuse himself because he hates me, and I know he hates me, and those can be a little bit dicey, and those are usually left up to the board to decide whether that is a sufficient display of bias that board member should step off. I'm of the view that you should do your best not to create appealable issues, and if having somebody step down or stepping down doesn't really impact things, doesn't impact the quorum, then, you know, stepping down is probably the conservative course of action, and probably the encouraged course of action. Nothing worse than finding out after the hearing that there's some bias. If you have an issue, if you think there is an issue, it's best to just get it out on the record and ask the parties if they have any objection to your participation. It's just the easiest way to do it, and it will certainly withstand appeal. I've got a section on liability, but we've got 5 minutes left. All I'm going to say is you really don't have much by way of liability exposure. You've got a number of protections under the Maine Tort Claims Act, and as long as you do what you're supposed to do, then you have no real exposure, no exposure at all. I have never in my life, in 30 years of practice, heard of a board member being held responsible. Most board members, I'm sure you're all that fall in that category, will do exactly what you're supposed to do, and do it with in good faith, and that's all that the law requires. Questions? Outstanding. You'll have a ton of questions on Thursday night, Wednesday night, Thursday night. A parting pep talk. I will get you that information, the appeal information on Friday. I will send you any follow-up information or evidence that the parties wish to present. And then we will just walk through it just as described tonight. And I expect a orderly hearing. Sophie?
Wanted to let folks know that I will have Nancy reach out to folks on Monday with just to talk briefly about any technology needs that they might have or training that they might need in order to be able to participate in this process. So she's not here tomorrow or Friday, but she'll be back Monday, and I'll have her reach out at that point so we make sure everybody's comfortable with what they need for the meeting.
Good. All right. Well, then I will look forward to seeing all of you. It's Thursday night, isn't it?
Yes.
Yeah.
Thursday
I
the
look forward to
20th.
I look forward to seeing all of you on Thursday evening. And listen, Sophie has my email. I will have all of your emails because I will get you those items. If you have any questions, if you have any questions about Board of Appeals and your work, not related to the appeal, feel free to reach out to me. I hit you with a lot, but if you think of something, just feel free to reach out to me.
So will the agenda include the election of a chair as our current chair is recused out of the meeting?
It will. I have it set up, Shane, that item number 1 is the election of a vice chair.
Okay.
For a vice chair who would take over, obviously, for the chair. I did not know whether Bill had been elected as the chair
Years ago.
years ago. You guys are lucky.
Well, the last time I remember that we met, and I don't think I missed any meetings, was some years ago, and Bill was the chair and did a great job. And I'm thinking, oh, he's not going to be there. So
Bill's great. He's been doing it for years. When he lived in Hamden, he did it, and he's super experienced. He's great, and he's a trial attorney, and he knows how to run a meeting, and so he's great. I think Shane, your father, Francis, I think he was on the board when I was on the board.
Oh, I don't think he was ever on appeals.
No?
He was always on council.
Oh, maybe he was on council at the time.
No, I was on appeals back then. I was on appeals with you.
You were on the board.
Yeah.
You were on the board.
Oh, yeah.
You were on the board.
Yeah.
Have you been on the board that whole time?
Yes.
Wow.
wow, how many years, Shane?
I don't know. 25 or so, 25. Gary's been on a long time too.
Yep.
He used to be
Yeah,
chair.
I remember how long I've been on, not that long. And I said, if there's somebody else interested and the council has someone else they would like to appoint, because I started out as a alternate member for a while, and then I became a full board member. But they said they didn't have anybody else that was looking for the job. So I said, sure, I'd be happy to serve because it has not been a big burden at all.
It really isn't. I've been on this committee, and this is the first time meeting. I've been on this committee, I think, 4 or 5 years, and I have not met or even been in any, nothing has happened. So
It's perfect resume material.
Well, that means
Not
our
grammar,
CEO,
no work.
Right.
if we don't meet, that means the code enforcement officer's doing his job.
You know, Shane, that is exactly that has been my view the entire time I've been practicing. Is it's the code officer sort of that where the people enter the process, that if they can do it, or even if they deny it, as long as people understand that why they were denied, it makes all the difference. That's a compliment to the Orono and its staff.
I think the last time this board met, I think it was David Chase was the chairman.
No, Bill's chaired a meeting or two.
Yeah, Bill DeVoe, the last time I remember.
I started with Dana DeVoe back in the,
With Dana DeVoe?
yeah.
Yeah. I miss Dana.
Wow.
Wow. Shane, I apologize. That is absolutely, it was you that was on that board.
Yeah.
That's where we met.
Yeah, it was.
That is
Oh,
where
yeah.
we met.
Oh, yeah.
That is exactly, you are exactly right. You are exactly right. So you were the one, you also probably voted to grant Orono VZ Water District a variance, but that's neither here nor there.
Yeah.
Yeah. All right.
Uh-oh, boss is back.
She never left.
All
She was in the building. She was behind the building. We're done.
right.
We'll see
Good
you
night,
all. on
everybody.
Thursday. We'll see you
See
all
you
Thursday night.
Thursday in one form or another.
Thank you.
All right.
Bye.
Everyone. Good
Bye.
night.